Welcome, everyone, and thanks for joining us during your lunch hour on this Wednesday, September 11th. And we are planning to spend the next hour discussing the political activities of Public Entities Act and the constitutional amendments that are on the ballot. I'll wait to get started until a few more participants make their way in, but we're excited to host you and have this conversation. All right, looks like we've got a critical mass of those who registered who have tuned in. So thank you again for joining us for this webinar by the Utah League of Cities and Towns. I'm Cameron Dale, the Executive Director of the League, and between Justin Lee, our Deputy Director, and Jared Tingey, our Legal Director, and I, we will be walking through the political activities of Public Entities Act, as well as the state constitutional amendments, and answering questions, which we're allowed to do under the Political Activities of Public Entities Act about those ballot propositions. This may be the least exciting opening slide of a PowerPoint ever, but I think it's important to set up what we hope to accomplish over the next hour or so. So the first piece is that this is not, we are not acting as your legal counsel. We are providing factual information, which the Political Activities of Public Entities Act allows us to do about ballot propositions. And then the second question here is, why is the League doing this webinar? Well, we are doing this webinar because we as a league are a public entity and U.S. cities are public entities. And this is an interesting election year with significant bonds, taxes, constitutional amendments, and other propositions on the ballot. And over the last few weeks, we've received a lot of questions asking what public entities can and cannot do during this election cycle. And then we've also fielded questions about what elected and appointed officials can do. And that's what we hope to address over the next hour or so. Also point out that last week at the League's annual convention in Salt Lake, Justin Lee, our Deputy Director, thank you, Margaret. We'll work on that audio. My computer is having issues, which is why I'm using Jared's right now, and then I'll be handing back off to Jared here momentarily. But last week at our annual convention, Deputy Director Justin Lee took to the general session stage and gave a high-level overview, and then asked for questions via Slido about both PAPEA and the constitutional amendments. Under PAPEA, we are allowed to answer direct questions, and so we will be addressing those questions during the webinar today. Likewise, next Monday, September 16th, will be the Legislative Policy Committee, but the League Board nor the League Policy Committee can take positions on ballot propositions because as a public entity, we cannot influence a ballot proposition. We can provide factual information, which is what we intend to do today. Likewise, we have been working on a white paper and additional answers to questions that we'll be distributing soon. And I will acknowledge that today, this afternoon, there is a court hearing about Constitutional Amendment D and whether it'll be on the ballot this year. So we are holding off on our factual information in print until we have that ruling, and we're waiting for the information pamphlets that will come with the ballot proposition. So with that being said, you can ask questions in the chat room. Those will come directly to us, and we'll try to address a list of questions that we have already received over the last week. With that, Justin, I'm going to turn it over to you as Deputy Director, and Justin is really our secret weapon on this overall issue because he formerly was the Elections Director and knows the Political Activities of Public Entities Act better than probably anyone in the state, and how it applies to public entities, but also how it applies to elected and appointed officials. So Justin will take a few minutes to walk through that, and then we will walk through the constitutional amendments. Justin, take it away.
Thank you, Cameron, and good afternoon to everybody. Happy, I don't know if happy to be here is the right thing, but I'm glad we're going to take a few minutes to talk about this. I can tell you over the years, as I have worked on this code section and worked on complaints about this code section, worked through this with different cities, counties, and agencies, that it's a tricky code section. and people need to be careful about what they do, not just for legal reasons, but for political reasons. The Political Activities of Public Entities Act, or PAPEA, is one that has got some people in trouble over the years. So regardless of constitutional amendments, there were things that we want to talk about this year, because we know, like Cam said, that there are bonds, there are other ballot propositions, there are local referenda and things going on. So first off, and we're going to mention this a couple of times, just because the terminology matters here. But there is a difference between an initiative and a referendum. A lot of people use referendum broadly to mean anything that goes on the ballot. But under the law, there are two separate processes for initiative and referendum. So an initiative is a new law initiated by members of the public. We do not see a lot of these at the city level. We have seen some at the state level over the years, but this is when the public or members of the public come and actually initiate a brand new law. A referendum, on the other hand, is when a law passed by a legislative body is referred to the voters. So when we talk about a referendum throughout the course of this webinar, we're talking about something that a legislative body passed. So you passed a law at the local level, city council passed a law, and then the voters refer that, some voters refer that to the full voters on the ballot. An initiative was when a new law is initiated by members of the public. My guess is that if you've had experience with one of these two, you're more likely to have had experience with referendum than you are with an initiative. So just want to clarify that one, and we're going to clarify it again because differentiation does matter a little bit. So who does this apply to? A few more definitions here. First, a public entity. Public entity includes the state and each state agency, municipalities, so probably everyone on this call here, and governmental interlocal cooperation agencies. So this is where ULCT, the league, gets pulled in. Now, a ballot proposition includes a constitutional amendment, initiative, referenda, bond approval, or other questions submitted to the voters. If there's something else that's submitted to the voters under the statute, those are all ballot propositions, and those are the public entities included. So here's the quick overarching answer about what you can and can't do. Unless specifically required by law, a public entity may not make an expenditure from public funds for political purposes or to influence a ballot proposition. Now, a couple more terms there we've got to define. One, political purpose. So political purpose in the code means influencing people to vote for or against candidates. So when it says you may not make an expenditure from public funds for political purposes, it means you cannot use public funds to influence people to vote for or against specific candidates. Now, influence, and this is kind of a weird definition because influence is included in the other ones, but when we say influence a ballot proposition, it means to campaign for or against a ballot proposition. So cannot use public funds or make an expenditure from public funds to influence candidates or people to vote for or against candidates, or to influence people to vote for or against ballot propositions. And the majority of what we're talking about today are those ballot propositions. So there's a penalty. Each public official who violates, that's the code section 2011-1203, is guilty of a Class B misdemeanor. Now, I'm going to reiterate again what Cameron said at the top. We're not your attorneys. This is not specific legal advice. Whoa, and I'm not sure why that got so zoomed in there. That was exciting. Hold on one sec. There we go. Now, we're not your attorneys. We're not going to be the ones to defend you if this happens. I will tell you from experience that there are not a lot of prosecutions that happen under this one, but there are concerns that even if someone makes the complaint and you've got a ballot proposition on the ballot, then I guarantee that they will bring up that complaint has been out there, and that's going to cause political headaches for you. So nobody wants to be in hot water either, criminally or politically here. So there are penalties. There are specific penalties that come out and specific prohibitions for using email. Just to give you a little bit of quick history on this one, what we're seeing through the years is most of the violations of this came from people using email to either advocate for or against candidates or for or against ballot propositions. So legislature put specific laws in about email. So a person may not send an email using the email of a public entity for political purposes, again, for candidates, or to advocate for or against ballot propositions. This code section has a separate penalty. After giving the person notice and an opportunity to be heard, the lieutenant governor shall issue a fine of $250 for the first violation and $1,000 multiplied by the number of violations for subsequent violations. So this is one that this comes up, like they said, the criminal one, I haven't seen a lot of people prosecuted under that one. I have seen entities get fined. And I should admit, I have been a part of fining entities who have crossed the line with emails. So this is one that can happen. Again, Lieutenant Governor's office will give you an opportunity to be heard. You'll get notice, and then you may get fined. So be very careful about using your email for these political purposes. So we're not going to have time to go into every single detail of this one. Again, check in with your attorneys, make sure that you're on the right side of the law when you're putting out any information about ballot propositions in particular. But we do have a fact sheet. We sent it out last week in Friday Facts. We'll be sending it out again. And it walks through the specifics and the exclusions in the code, what kind of factual information you can put out there, what access you need to give to both sides, and then information about the constitutional amendments as well, as Cameron mentioned earlier. Again, for those specific questions, please talk to your attorneys and check in with them. So a couple of just cautions on this one. Make sure your facts are in fact facts. What we see happen from time to time is that, for example, let's just take a bond. If you as your council had voted to put a bond on the ballot, you think you need that bond. You're convinced that you need that bond. You see the need for it out there. And then it gets very difficult to separate the advocacy from the facts. And so to do the ridiculous example, and I did this last week, I make it all the time. But if somebody says, if this public safety bond does not pass, the apocalypse will happen, all of city government will crumble, the republic will fall, that is not a fact. That's going in advocacy. If you talk about, the fact that if the public safety bond doesn't pass, then we won't be able to build these things. Here's where our capacity is at currently. Then you're in the realm of facts. So just give you that caution. Most of the time, if it's a referendum and it's something that has been referred that you voted on, or it's a bond that you voted on, if you're a council member or mayor to go on the ballot, obviously that's something you want. That's something you think is a good idea. But just be careful that the facts that you're sharing are facts and are not subjective and leaning into advocacy. Now, all of that being said, there's nothing in the code that prohibits a public official from speaking, campaigning, contributing personal money, or otherwise exercising the public official's individual First Amendment rights for either political purposes or to advocate for or against a ballot proposition. So on your own time, using your own resources, there's nothing that stops you from advocating for or against candidates or for or against ballot propositions. A good rule of thumb here is that if somebody in the public has the same access or the same ability to do it that you have as a city official would have, then you're okay. If you have special access, because you're a city official, either to a newsletter, again, to email, if you could reserve a room without paying for it as a city official, but a member of the public needs to pay for it, you want to make sure that you're on that same playing field as members of the public. So again, you can do this on your personal time with your personal resources, but just want to be careful about where that line is at. So we asked a lot of questions, or excuse me, you asked us a lot of questions last week about what can we do and what can't we do? We took in dozens of questions, and then there's a few of those we want to spend some time asking. If you have additional questions, right now just about the law and how it works, feel free to ask those in here. We'll take a look at those and then we can answer them. But just want to take a few minutes here and answer this. So one of the questions we got a lot is it legal to create a website to provide facts on a bond proposition? So there's a couple of sections of code that deal with this. So one, factual information, a public entity may provide factual information so long as the information grants equal access to both opponents and proponents of the ballot proposition. And then you can research and gather information with equal access. So you can conduct research, collect and compile information, and provide arguments for or against ballot propositions, so long as the information gives equal access to both sides of the ballot proposition. So yes, you can have a website, you can give factual information, but you also need to provide an opportunity and a forum on the website for people who are both for or against that. Again, on this one, you can post on the public entity's website or any medium a complete copy of the ballot information. So you have to do a voter information pamphlet. You can post that. That's fine. There's no concerns about that. On the website, you can also post a link to another website not owned by the public entity, so long as a public entity takes certain steps before posting the link. And I apologize in advance, this next slide is messy. It's basically just the code, but I just wanted to show you what the next steps are. Basically, if you look down there on little I, if you're going to post a link to another website that is not controlled by the public entity, you need to give notice, and it says provide at least 7 days written notice to the sponsor of the ballot proposition, proposed initiative, or proposed referendum of your intent to post a link to the other website, a description of each medium, the dates for the posting, and then give them an opportunity to respond with other links. So again, if you're going to post information, you need to make sure that you're giving the other side an opportunity to be heard there as well. So yes, you can create a website. Yes, you can post links to, if there's a friends of, local district bond that's created out there, you can do that. But you also need to give an opportunity for lack of a better term, enemies of local bond, if they would like to post something as well. So can I answer questions about a ballot proposition? Yes, you may answer questions. The law allows you to spend a reasonable amount of public funds to gather information for and respond directly to an individual's questions relating to a ballot proposition, proposed initiative, proposed referendum, or referendum. Be careful not to move into advocacy or tell a person how they should vote. So again, if you have a bond, if you have something on the ballot and they reach out to you and you need to answer their question, you can do that. You can explain even the reasoning by why you put that on the ballot. Say the reason that we decided to put this on the ballot are X, Y, and Z. Again, just be careful that you don't move too much into advocacy, or not even move too much. Just don't move into advocacy when you're providing that factual information. So yes, you can answer questions. That's all right. You're allowed to do that. Just be careful you don't roll into advocacy when you're responding to that. And this even allows you to take some time, if you need to do the research or have some staff do research to respond or gather information, you can do that. Can I answer questions about a ballot proposition via email? Yes, you may send email to the following individuals or groups of individuals: a person or group who asked a question for the purpose of providing them information in response to their question. So yes, somebody asks you the question via email, you can respond with that factual information via email. Again, be careful not to roll into advocacy. But yes, you can respond, so you can answer questions. You can do that via email. So this was a direct question someone asked. If a city has a ballot question, there is necessary preparation of voter information pamphlets, including arguments for or against that involve staff or elected officials. Where is the line between preparing for the ballot proposition and campaigning? It is a really good question. So the law lays out specific requirements for preparing the voter information pamphlet, for preparing the ballot proposition language. Tells you the notice you need to give. It tells you the time you need to spend on that. So if you're following what is in the law, you're not in violation. You're going to be fine. Prepare that voter information pamphlet, doing everything that the law requires you to do. It's anytime you start taking steps beyond that you need to look at. For example, if you're going to do a website, there's nothing that says you have to do a website or put the information on the website beyond the voter information pamphlet. If you're going to do that, then you need to start looking at the code and making sure you're following that you're not going beyond what's required in the code there. If the city is going to bond for infrastructure or endorse a PID, can we speak of it as public information in the city newsletter? Another one that's going to be related for this is, can I say my opinion on a large annexation? So 2811 Part 12 PAPEA only applies to things that are on the ballot, to ballot questions. So if you're going to bond for infrastructure and it's not going on the ballot, if you're going to endorse a PID, if you're going to have a large annexation, whatever that is, nothing in this code section applies to that. It only applies once it's either potentially going to be on the ballot or once it's been verified to be on the ballot. So nothing stops you from speaking, giving your opinion of things. The code section doesn't apply until either the application has been filed for a referendum and you're in, there's a potential ballot question there, or it's qualified for the ballot and it's actually going to be on the ballot. So constitutional amendments are an interesting thing this year. There have been times in the past where cities have given their opinion on things that could be on the ballot, but until they actually qualify to be on the ballot, you don't have the handcuffs on that you do under PAPEA, if that makes sense. So you can say whatever you want about various topics in your city until they become ballot questions, and then you've got to be careful under 2811 Part 12. That was the question that we received last week when we asked. I know I went through those fairly quickly, but if you have other questions, this is your chance to put those in the chat, and we can take a minute to answer those questions. So I'll just leave that open there for a couple of seconds before we jump to the other things. But this is your chance. If you have questions, ask them now. And I won't say forever hold your peace, because you can always reach out to us after the webinar if you have other questions. You can always talk to your city attorney, and you should. But yeah, if you have other questions. So a couple of people, will we share the slides? Yeah, we're happy to share these slides with you. That's not a problem at all. We may tweak them after we get the questions. Yeah, we're happy to share these slides with you once we get them in their final form.
Well, Justin, as questions come in through the chat that are related to the Political Activities Public Entities Act, we'll keep an eye on those. Are you comfortable if we proceed to talk about the constitutional amendments, and then we can come back with the PAPEA questions that come up?
Yep, absolutely. Particularly since I don't have to talk very much anymore, so I'm very comfortable. Oh, okay. We've got a few questions coming.
So there are a couple. Yeah, there are a couple that come up that I think go ahead and hit these ones, and then we'll proceed.
All right. So question, elected officials are always asked their opinion. Can they answer those questions? And yeah, so the answer is yes, so long as. So if someone asks you a question, you can answer that and give factual information. You can say, yes, I decided to vote to put this bond on the ballot, and here are the reasons. Giving your reasons that you decide to put something on the ballot, you can respond to that. You just want to be careful that you don't slide over into advocacy and tell people they should vote a certain way. So elected officials can give their opinion. They can explain their reasoning. They just want to be careful they don't slide into advocacy when they do that. Let's see. An opponent to a ballot proposition can state false information, and the public entity can answer with factual information without advocating. Yeah, that's a great question. So you can provide factual information. This is, I would say it blatantly, it's a little bit unfair that if someone's opposed to something, they can kind of say whatever they want, and there's not really a whole lot you can do there. The best you can do is provide factual information back. If someone is out there spouting kind of misinformation, there's not much more you can do than say, here's why that's misinformation. Here's the factual information. So you can go back and forth, but again, you have to allow both sides opportunity to provide the pros and the cons and their thoughts. What about the county mayor attending the city council meeting to discuss the new bond? It's a similar thing. So you can hold a public meeting here. So you can have public meetings that discuss ballot language. You just have to make sure you give opportunity to both sides, is what the law requires. So you can give factual information, but even then, and again, we'll send out our fact sheet that gives this information, but you do have to allow opportunity for both sides to speak. Let's see. So I think with that, I think let's jump to their side, and then we can maybe answer a few of these questions later, depending on where they're at. And some of these are good questions that we'll look at them and make sure that we're answering in our fact sheet. So Cameron, I think let's move on to the next part.
Perfect. So please keep putting questions in the chat room. We'll have some time at the end as a catch-all for questions. And then part of the reason we have not published our white paper yet is because we want to make sure we're collecting as many questions as possible, because the league is a public entity and we can respond to questions. So thank you for putting the questions in. Keep them coming. Justin, will you advance to the next slide here? Now this year's ballot, depending where you are in the state, will have a lot of interesting, significant things on it. We as league staff asked ourselves the questions like, how much detail should we go into about a proposed school district split, or a proposed public safety bond, or RAP and ZAP taxes, or school district bonds, or any number of those. Ultimately, what we're going to focus on in this webinar is what will be on the ballot statewide, and that is the 4 ballot or the 4 constitutional amendments that are proposed. I will note that in our white paper that we're working on with the Political Activities and Public Entities Act, there is a specific path around the school district splits that the legislature put into code a few months ago, and so we'll have some acknowledgments there, because it's a little, there's just some unique details there to consider. So that being said, let's talk about the 4 constitutional amendments. Again, the league as a public entity cannot take a position on any of these 4 constitutional amendments, but our objective here is to provide you with factual information, recognizing that legislators put these amendments on the ballot, and therefore it is highly likely that legislators will contact mayors and council members to ask for their positions on these constitutional amendments. And that's a key point around constitutional amendments, is constitutional amendments go on the ballot because the legislature approves them. So you cannot initiate a constitutional amendment. It has to come through the state legislative body. Amendments, the amendments that are currently slated for the ballot are amendments A, B, C, and D. I'll start with Amendment A. So Amendment A has been referred to as the income tax constitutional amendment. Going back to 1931, Utah voters created the income tax earmark to the Constitution. In 1931, 75% of income tax revenue went exclusively to public education. In 1947, voters changed the Constitution to make it 100% of income tax revenue for public ed. And then in the late 1990s, voters expanded the income tax earmark to include higher education in addition to public education. And then in 2020, Utah voters again modified the income tax earmark to where now income tax can be used to support children, support individuals with a disability. So currently, income tax in the state of Utah can only be spent on public ed, higher ed, and to support children and individuals with a disability. The proposed constitutional amendment would modify that and would allow, after those expenses, would allow the state to use income tax revenue for other purposes. Justin, can you go to the next slide? Because a key component of both Amendment A and Amendment D is that there are additional state statutes that would go into effect if voters approve Amendments A and D. In the case of Amendment A, there's an additional bill that would go into effect that would remove the state sales tax on food and food ingredients. Currently, that sales tax is 1.75%. Under the current tax structure, if you purchase something that is taxable but is not food or food ingredients, you pay the full state sales tax rate. If you purchase food or food ingredients, you're paying the lower state sales tax rate of 1.75%. On top of that, you're still paying the city 1% and the county 0.25%. If Amendment A passes, then the legislature in statute would remove the state sales tax on food. So that 1.75% would be removed. the local portions would continue on sales tax on food. Amendment B. Amendment B is also related to school funding. This is actually a pretty simple change. Currently, the state school fund, which receives revenue from the sales of federal land to the state, school trust lands, and non-renewable resources on state lands, that state school fund may transfer up to 4% of the fund to the state in support of public education. Amendment B would increase that from 4% to 5%. Amendment C. Amendment C would establish in the state constitution that a county sheriff is an elected official. Currently, the state constitution is silent about the county sheriff being a constitutional elected official. All 29 counties in Utah currently elect their sheriffs. That's been practiced dating back to 1854. There are many states around the country that have enshrined the county sheriff as an elected official, and the constitutional language does not change any of the legal duties or responsibilities of the county sheriff or the relationship between a county sheriff and a municipality. It would simply state that a county sheriff is an elected official. Amendments B and Amendment C do not have any other bills that would be triggered if they pass. Then we have Amendment D. And Amendment D, as I mentioned when we started the call, there's actually a court hearing this today about Amendment D, so stay tuned there. But for now, we are operating under the premise that it will be on the ballot. Amendment D would provide in the Constitution that the state legislature, as well as city, town, and county legislative bodies, have the power to amend or repeal a citizen initiative, and it would prohibit foreign individuals from influencing a ballot initiative. And there is an additional bill that would go into effect upon the amendment passage that would require the legislature to give deference in the legislative session subsequent to the passage of the initiative if they were to make changes to that initiative. So the constitutional amendment would say, it would make it clear that the lawmaking body can make changes to amend or repeal, and then there'd be the statute that would require the legislature and the legislature only to give deference in that subsequent that subsequent session. We're going to take a moment now. I'm going to turn it over to Legal Director Jared Tingey to answer the questions that we received last week at the annual convention. And then I'll come back and talk through where we're at with the Supreme Court framework and what this could mean if you had a local government initiative, if Amendment D passes, or if Amendment D does not pass. Jared, take it away.
Thanks, Cam. To begin with, I just wanted to go back to this slide discussing what an initiative is versus a referendum. So an initiative is a new law initiated by members of the public, whereas a referendum is a law that's been passed by a legislative body and then is later referred to the voters. And so, Justin, if you could, so what does this Constitutional Amendment D do, and how does it affect cities and towns? So with this Amendment D, this is the actual proposed language, notwithstanding any other provision of this Constitution. The people's exercise of their legislative power as provided in subsection 2 does not limit or preclude the exercise of legislative power, including through amending, enacting, or repealing a law by the legislature, and this highlighted portion is where the cities come in and towns, or by a lawmaking body of a county, city, or town on behalf of the people whom they are elected to represent. So what this does, and it only refers to initiatives versus any sort of referenda. And so always keep that in mind, that Amendment D does not reflect or impact any sort of referenda, just initiatives that have been passed. So we've received a lot of different questions related to the Constitutional Amendment D. The first one here, what is the state and local government's current legal authority to modify initiatives after they have become law? before jumping into the legal answers, the practical answer is that prior state initiatives have actually been modified in the past. After the initiative has been passed, the law has been modified and changed. For example, medical cannabis with Prop 2, as well as Medicaid expansion with Prop 3. Generally speaking, there's been very few local initiatives in the past that have been considered or passed. And to answer the question on the legal side of things, what I can do is tell you what we do know. There are a lot of there's a lot of legal moving parts still, and some of which the Supreme Court answered, others which they did not. So the things that we do know, the first is in the Constitution, the people have legislative authority to make laws through initiatives. The second is that people have the right to alter or reform their government. And there are questions as to what initiatives alter or reform government that we won't answer here. And then the third is the Supreme Court, in its opinion, said that government cannot change laws made through initiative unless one of two things. The first is the changes facilitate or support the reform. That would include any technical changes. And then B, changes that are done by the legislature that are narrowly tailored to advance a compelling government interest. And so that is the framework by which we currently, what the current legal landscape is to modify initiatives after they become law. The next question is, if Constitutional Amendment D passes, what effect will it have on local ballot propositions, including city initiatives and referenda? So to answer that, if it does pass, cities and towns, legislative bodies will not have any limits on amending, enacting, or repealing initiative-created laws, including for those technical and substantive reasons, or really any reason whatsoever. And then, as I've said before, really the city referendum process is not affected by Amendment D. If Amendment D does not pass, then it would default back, at least at this point, to the Supreme Court framework of alter and reform government. Next slide. So right now I'm just going to pass it over to Cam to go through a few examples as to what would be allowed if it does pass and what would not be allowed if it doesn't pass.
Perfect. Thank you, Jared. And there are some unanswered questions from the Supreme Court decision in July, and hence the ping pong back and forth of if this, then what. And that's what we're going to try to highlight here, with the acknowledgement that these are the unanswered questions. So we're going to give you 3 examples of how the framework could apply. So example number 1 is in the land use context, but if the city has an ordinance around the placement of trails, and residents do an initiative that changes that ordinance and the location of those trails, if Constitutional Amendment D passes, then the legislative body could, after the initiative passes, change the law back to what the old law had been. If D does not pass, then that Supreme Court framework applies, and you would need to ask the question, does the initiative alter or reform government? And if it does, then the city legislative body may amend it, so long as they meet the standard of a compelling governmental interest, or to make technical changes to support the reform. And what's in quotation marks are pulled from the Supreme Court decision. If it does not alter or reform government, then the city legislative body may amend. Well, one key unanswered question from the Supreme Court decision is what is alter or reform. So is, changing your ordinance about trail placement, is that altering or reforming government? That's an unanswered question at this point. Example number 2 addresses this in a budget setting. And so let's say the city is currently budgeting 40% of revenue for public safety, and there's an initiative that says you have to city budget 80% to fund public safety. If Amendment D passes, then it clarifies that the city legislative body could fund public safety as they see fit for the needs of the city. The residents will have said 80%, but they could alter they could amend that as they see appropriate. If D does not pass, then you apply the Supreme Court framework. So does the initiative alter or reform government? Is the budget exercise altering or reforming government or not? If it is altering or reforming government, then the city legislative body may amend the initiative, which in this case is that percentage, if they have a compelling governmental interest, which is also known as strict scrutiny, or they can make technical changes. But if the initiative is not altering or reforming government, then the city legislative body may amend without meeting that standard. I also want to point out here that I'm giving the legal response and asking the legal questions, as opposed to whether or not your city council would politically want to change initiative after it passes. That's a political question. We're trying to stay focused here on the legal question of what you can and can't do legally. And then with example number 3, this is actually a fascinating case study. Let's say in your current city law, the mayor is the executive branch, city county is the legislative branch. Under current state law, in order to change a form of local government, there must be a vote of the people anyway, okay? So let's say there's an initiative in Cameron City to change from the mayor-council form that we've outlined above to change to a 3-member commission form of government, similar to what you see with county commissions. So if D passes, then the city legislative body could take what the voters said in the initiative, changing it to the 3-member commission, and they could change it back to the mayor-council form. But there is the caveat that state law, not the Constitution, but state law requires a vote of the people when you change a form of government anyway. So it's an unanswered question of, if D passes, could you change it back, or would it still need to go back to the vote of the people? If D does not pass, then the Supreme Court framework applies again. So does the initiative alter or reform? If it does, then you can amend if you have a compelling governmental reason, or you can make the technical changes. If it does not alter or reform, then you can amend the initiative without meeting that standard. So we tried to give you a variety of examples to think through what could alter or reform mean, with the key point that the court did not define what alter or reform is. And with respect to the specific fact pattern before the court, they actually sent that back to the trial court, the district court, to consider that. So, a lot of unanswered questions still to be addressed there. Okay. We've hit you with a lot. We've got our white papers that we're working on that will be available soon. Part of the reason we haven't published them is because we wanted to have this webinar to secure more questions, acquire more questions, and be prepared to answer them. But there are currently resources available now, the Supreme Court case that started this discussion, as well as the full text of each of the constitutional amendments, and then the state voter pamphlet is being prepared, and our white papers are being prepared. What additional questions do you have for us about PAPEA, about the constitutional amendments, or anything in between? While we wait for questions, and we'll keep this open for a few minutes, I said something earlier that I just want to put an exclamation point on. The league is a public entity, so we cannot per PAPEA take a position on any of the constitutional amendments. Justin City could not take a position on any of those ballot propositions, though Justin City could, under PAPEA, do public meetings as long as you provide equal access, provide factual information alike. And we are trying to provide that factual information to you. But mayors and council members recognize that legislators put these constitutional amendments on the ballot, and they will be calling you, if they haven't already, seeking your support for these constitutional amendments. That's why we want to make sure you have as much information as possible about what it means for cities and then what it means generally. So just be prepared that those calls are likely to come in your individual capacities, and you have your First Amendment right to speak up as you see fit. Okay, so with that, what questions do folks have, or did we truly answer all of them?
So, Cam, I think one of the questions from earlier was if the mayor doesn't have a vote, what are the limitations of advocating without using government resources? And the answer is they're the same as anything else. It doesn't matter whether you had a vote or not. And I think, Cameron, what you just said is important. If it's a ballot question, it doesn't matter if it's your city's ballot question. It doesn't matter if you voted on it. You can't use those government resources to advocate for it, regardless. So again, to take kind of a silly example, if you're in Kanab and you have a strong opinion on what Logan is doing for some reason, you can't use government resources to advocate for or against a ballot proposition in Logan. If it's on the ballot, you just can't touch it with government resources.
Yeah, thank you, Justin. I'm scanning the other questions to see, there's the question about equal access in other mediums. Do you want to address that now, or is that something we should double check in PAPEA and just address in the white paper?
Yeah, we can address that in the white paper. So the question is, other than websites, do you have to give equal access? And I think the important thing to remember here, just kind of as a rule of thumb, is if the law doesn't require you to do it as a city, and it's not somewhere where you can quickly give equal access, then you should really think hard about whether or not that's something you ought to be doing. So again, check with your attorneys, look through the code. I would say cities are creative, as I've seen through years of finding different ways of putting things out there. So I think be careful if you're putting anything out that you cannot give equal access to. You're always allowed to tell people to vote. You're always allowed to say, here's the voter information pamphlet. Please go read that. But if you're just sending out straight up factual information and there's not a good mechanism for providing equal access, you want to be careful. I can tell you from past experience, there have been times that, and I won't even say it's a city, I'll say it's a school board because that's the one I'm thinking of, where a school board did put out information. Obviously, once a mailer has gone out, you can't tag something onto that. So what came back is the county attorney told that school board that they had to then put out a separate mailer with information on the other side. So if you can't give equal access, I'd be very careful about what you put out there, even if you think you're just doing factual information.
And Justin, I'll add to that piece. The question was if mayor doesn't have a vote, which in most, many cases that is the case. Recognize that once you are no longer conducting the meeting at City Hall, you still have all of your First Amendment rights. You have your personal Facebook page. You have your personal contact list. You have your ability to weigh in and say, I support or I oppose X, Y, and Z. And that's the point I've made a couple of times here, that I anticipate legislators will call you as the mayor and say, Mayor, we get that the city can't take a position, but we really would like your support, and we think that this amendment's good for cities. We think this amendment's good for the state. We think this amendment's good for X, Y, and Z reasons. Do you support it or not? And that's where you as an individual, you have your First Amendment rights to say, yep, I support it, or no, I don't. Okay, so there's a question about the last slide with reference to website information about guidelines be a model for local government website. And Justin, I'll let you answer that because that's more in the PAPEA space.
So a couple things. If you're gonna put out a website, just a reminder, you need to give equal access to both sides. You can link to the voter information pamphlet. So that's what we've got here is a link to the voter information pamphlet. I think I'll use this one to answer a question that wasn't asked, but does get asked fairly often. What if there is not an opposition? And there's two answers to that. One, if you don't think there's an opposition, double check, check Facebook, make sure no one really is opposed to this thing. Because there may be. And two, if you're going to put something out there, put that notice up that says, if someone would like to write an opposition to this, they're allowed to. Here's where that is. But then one thing that I've seen that's been effective over the years is that if there's not an opposition, sometimes you put out that statement that says, we have asked for opposition statements. We have not received any. If you're interested, put one here. So it's clear to everyone that you've at least done the effort to put that out there, even if ultimately nobody puts out any other information. So if a city created a video, okay, this is a good question. If a city created a video in support of RAP, before there were, is it okay for the city to promote or post the video now? I think, so there's an interesting question here is, the closer you get to something being on the ballot, if it's in support of something, then you look like you're going to be supporting, RAP being on the ballot. So I think you want to be careful there. If it's just providing factual information, I think that's something separate. So I would be careful of anything that supports or indicates support for something that's going to be on the ballot. If it's factual information, I think that's something that, in the last 10 years, here's what RAP has done. I think that's a different statement. So I would be careful of putting out something, though, that just straight up supports it. And again, I'll also say this, like for the 20th time, check with your city attorney if you get into trouble, or someone files a complaint saying that Justin or Cam or Jared said it was okay is not going to do you much good.
Yeah, that's right. And the piece I'll add to that is the question was if the city created a video, because that's the use of public funds and public resources. But the city knows what RAP was spent for. And that's the factual information piece that Justin's referencing. So if the mayor on her or his own Facebook page, or, I'm showing my age by only referencing Facebook, but on their social media platform says, I support RAP because it's done these great things in our community, and you're not using the city webpage and you're not using city resources, you can use your First Amendment rights to advocate for that ballot proposition. So that's why we're trying to be as clear and distinguish here of public entity versus you as the elected or appointed official, whether that's for a city RAP or a state constitutional amendment or anywhere in between.
So so I guess to reiterate that, if the city put out a video last year and you repost that on your own Facebook page, your private Facebook page, that's different. That's a different thing. Jared, I'm going to put you on the spot for a question here, because I know there has been both court cases and discussion around, what you're allowed to do and not do on your private Facebook or social media. Do you want to give a Spark Notes version of what you can and can't do that way?
Sure. I think to boil it all down, I think what's most important is to identify whether your Facebook page or whatever your social media account is clearly identified as private. And if you are on your public Facebook page, that you only post public things. Now, what Justin is referring to is a case that it's called Lynn v. Freed, and there's another case as well that that talks a little bit about making sure that those are separate, because the last thing that you want to do is mix those two, and therefore what you're doing on your private page can become an action of a public official. And to separate those two as best you can, whether it be a disclaimer, whether it be not putting on your private Facebook page that you've got a specific job title, city manager, mayor, and that you reserve that only for the public. Now, if you have those things currently on your Facebook page or other social media, does that automatically say that everything that you put onto that private Facebook page is now public and that you're acting as a public official? No, but the more and more you put that onto your Facebook page, the more you open yourself up to the risk of even though it's on a personal Facebook page or social media account, that now you are acting as a public official. So again, going back to the basic, make sure that they're separated.
Justin and Jared, while we wait to see if there are any other questions, we've mentioned several times that we've got a white paper in process about both PAPEA and the 4 constitutional amendments. The one thing we didn't really stress in the webinar, but we'll reference in the white paper, is that cities and towns have constitutional authority to make law and to pass legislation, pass ordinances, and the like. And so the language that is part of that proposed constitutional amendment builds off of that existing constitutional authority. So I just wanted to make sure to get that out there, that the city legislative authority exists in the Constitution now. I'm scanning the chat room and I'm not seeing any other questions. Jared and Justin, anything else either of you want to add before we wrap?
The last thing I'll say is just, as long as you're following the law, as long as you're doing what is required by the law, then you're going to be in a good place. I think where I've seen cities and school districts, counties get themselves into trouble is when they try to be creative about where they're going. So I think just make sure you're reviewing everything with the law with your attorneys. Be careful about where that line is, know where the line is, and be careful that you don't cross over it. Like I said, even if you don't break the law, even if you never get prosecuted under the law, even if a prosecutor never comes after you, if something looks kind of sketchy, like you've gone over the line, and someone files that complaint, they will immediately turn around and tell the media, put on Facebook or wherever it is, we filed a complaint because of these reasons. And then it really doesn't matter. Politically, they're going to use that as ammunition against, whatever it is on the ballot or for whatever they want on the ballot. So just be careful, be cautious about what you're doing. Take the time to look through the code before you do it. And as much as I know that we believe strongly on the things that are going on the ballot, if it's a bond or if there's something we really don't want because it's a referendum, just be careful. Try not to get yourself in trouble, and your fall will go a lot better.
Perfect. Jared, and then I'll wrap it up.
Oh, I don't have anything.
Okay, well, we had a question come in asking about the white sheet that went out last week's Friday Fact. So I'm glad we can clarify this. Last week's white paper was focused on PAPEA only. And since then, we've received a lot of questions. So we'll be updating the PAPEA section. The new white paper will also include the factual information about the statewide constitutional amendments. Because as I've indicated, legislators will be asking mayors and council members for their positions and asking for public support of their constitutional amendments. And we want to make sure you have all of that information. Because we're waiting on some finality at the court level, we've not yet released those white papers. And so once that gets finished, And then based on some of the questions we've received through this webinar, we'll be updating those white papers and have them out as soon as they are ready. And I echo everything Justin was saying about PAPEA, but just remember, particularly for mayors and council members, there is your individual capacity outside of PAPEA where you can engage and exercise your First Amendment rights. And legislators will be asking you and will be expecting you to engage one way or the other. And so that's why we want to make sure you have all the information in front of you so that you can engage as you see fit. Okay, with that, watch for more information in Friday Facts either this week or next week. Jared, there is a final comment from the legal director. I hope it's not to correct what I just said.
No. So just so everyone is aware, if you are an attorney, we will be submitting this for CLE credit. If you are interested in receiving CLE credit for this webinar, please email me at jaredtingy at jtingy@ulct.org, and that's jtingy TINGEY @ulct.org.
Okay. Oh, we just got one last question. Let's go ahead and address this one. The question is, does PAPEA limit individual state legislators in any way in lobbying city officials regarding the constitutional amendment? So this dovetails into the point I've been making throughout this meeting, that individual elected officials in their individual capacity can speak out and in support or opposition to ballot propositions, so long as they're not using public funds. So my answer to this question is, so long as they're not using public funds, then they can call a mayor and call a council member and say, we want your support or we want your opposition to these constitutional amendments. And they're following the same framework that mayors and council members are following. Just anything else you want to add there?
Nope, that's exactly right.
So it not only does the PAPEA not limit it, but I fully expect those conversations will happen in earnest over the next few weeks, and that's where we're trying to help you with all the information that you need. Okay, with that, if you think of other questions, feel free to text or email them to us. We'll continue updating our white papers so we can publish them. I appreciate your time today and I appreciate your involvement in the league. Watch for more information in Friday Facts, and we'll see you at the Legislative Policy Committee next Monday, where we will be hitting a whole slew of topics in anticipation of some big meetings in early October. So that meeting will be at 12:15 at the Local Governments Trust and online, and there'll be information about that in Friday Facts this week. It's September 11th, so hopefully everyone takes a chance to remember what happened 23 years ago, and thank you to all the first responders then and now, and thank you for your involvement within the league. Thanks, everyone.